Please take your seats. Council, have you had something to eat?
Yeah.
So we can carry on till Monday. So, I'm going to deliver my rulings on the points of law. Both parties raised, or all the parties raised since morning. Now, for starters, to do with affidavits, because the many points of law we are raised to do with most of the affidavits on court record. I have this to say. The Black Law Dictionary, 8th edition, page 178, defines an affidavit as a voluntary declaration of facts, written down and sworn by the declarant before an officer authorized to administer oath, such as a notary public, is further a statement or a declaration in writing, an oath or affirmation before a person having authority to administer oath or affirmation. It is supposed to contain only what the author knows as actual facts, and any second-hand information or information that is not witnessed or known by the person is inadmissible. Thus, what is required in affidavits is the knowledge or belief of the deponent and not any other person. An affidavit is therefore used as evidence. I further take note that Order 19, Rule 3 of the Civil Procedure Rules echoes the same position. I will now straight away go to the different points of law raised in respect to the different affidavits. I'll start with the PO that was raised in respect to the affidavit of Mwesigwa Alan. And the first point of law was to do with his failure to attach evidence of the letter of accreditation from the Electoral Commission. I do find that the failure of Mwesigwa Alan to attach evidence of accreditation as not fatal, since the same Mwesigwa Alan indicated in paragraph 9 of his affidavit, having knowledge of the facts he has averred to. I further take note that the same Alan swore the affidavit in the capacity of a news reporter of Next Media, was assigned by his employer to cover the events of the youth elections. And I referred to paragraph 1 of his affidavit. He swore in the capacity of a news reporter who was deployed by his employer to cover the events of the youth elections. So he did not swear the affidavit in the capacity of a news reporter who was sent by or accredited by the Electoral Commission. So I overrule that point of law. The second point of law was still to do with the affidavit of Mwesigwa Alan, and it was in respect of the statement of we that was used in paragraph 5 of the same affidavit. I do agree with counsel for the applicant that the word we presupposes that Alan and another did extract the video coverage herewith attached. I do find that since Alan was among those who extracted the video footage, he remains a competent witness to swear that affidavit in that regard. Because you see, like I have already highlighted above, for affidavit evidence, it is basically about the knowledge. And that is for affidavits. If you can ascertain that you have the knowledge to swear that affidavit, it is not fatal, even if you use the word we. What this court would basically guard against would be the other party coming on board and claiming to have done, for example, the extraction of the video footage when he or she did not take part or did not swear an affidavit. So merely using the word we, to me, it is not fatal. What this court has done is basically to align the same to Mwesigwa Alan. So instead of we, we've replaced the same with I, or in his own capacity. Because basically, the other facts, he averred having had knowledge about the same. So I'm also overruling that point of law. Then there was another point of law to do with the second and third respondent, or the affidavit of...
Your Worship, we can have 15 minutes?
If parties agree, who am I to say no?
And
let me hear from counsel for the first respondent as well as second respondent and third. Can we agree on time, or we leave it open? We should limit to how much time?
Give us
20 minutes. We are going to be very strict on time. Understood?
Most of that.
Now, that is going to be 20 for the applicant. Now remember your two, so you must utilize the 20.
Yes, Your Worship.
Then 20 for both of you. And you also need 20 since you're one.
No, I don't need 20. I don't
Then as for the rejoinder, if any,
Your Worship, we can use 10.
10. So she's going to time.
Most of that.
So don't blame court. It is by consent. In case you don't make up time. Understood? You time them. As soon as he makes 20 minutes, we
Your Worship, this application is brought under section 74 and section 77. Section 74
and 77.
And 77
Yes.
of the Parliamentary Elections Act.
Go ahead.
Your Worship, procedurally, it is brought under Order 52, Rules 1 and 3 of the Civil Procedure Rules.
Under Order
52, Rules 1 and 3.
1 and 3. With the CPR. Go on.
Your Worship, it is seeking for an order to recount all the votes cast.
Yes.
To recount all the votes cast for female youth representative in Parliament. That were held on 6th.
Are you timing? We are going to be very strict on time.
That were held on 6th February. Hoima City Stadium. Your Worship, the application is supported by the affidavit of the applicant dated 10th February 2026. And an affidavit by Turiage Collins, also dated 10th February 2026, and the affidavit in rejoinder by the applicant dated the 13th of February 2026. Your Worship, all those affidavits is what we invite the court to adopt as the applicant's evidence. To prove good cause for this honorable court to issue the order so. The applicant is a candidate, was a candidate for female youth representatives in Parliament. That's according to para 2 of her affidavit. And her grievance stems from the second respondent's presiding officer officer's conduct in counting the votes. Your Worship, according to paragraphs 6, 7, and 8, the applicant states that the presiding officer was deliberately reading and recording the applicant's votes as those of the first respondent. He was deliberately falsely attributing them as votes of the first respondent, whereas not. And Your Worship, counting of votes is a numerical exercise. It's a simple mathematical exploration.
It is a what?
A simple mathematical exploration. Of counting 1, 2, 3 upon attributing the ballot or the vote to the right candidate. So, Your Worship, where there is evidence as it is, the only remedy specifically paragraph 4 to Yahweh Collins, specifically paragraph 4, who states that according to his counting, and as an agent of the applicant who was present, he counted over 230 votes. Over 230 votes as votes for the applicant. Your Worship, that the court to order of we implore this honorable court, based on the evidence on record, to open the box. And resolve the electoral dispute at hand by recounting the votes. According to the second respondent's affidavit, it is stated that that election was free and fair.
According to?
According to the second respondent's affidavit by Munanra Ivan, it was stated that the election was free and fair. A free and fair election is that can stand the test and the only way to test and controvert the applicant's evidence on miscounting is to order for a recount. Is to order for the only way to specifically controvert this mathematical exploration of counting is for this. Last point, right, Your Worship, and my colleague, for my colleague to come in, is that in the event that the order is issued for the recount,
In the event,
and it's our strong submission that in the event that the order for recount is issued, unlike the other general elections, the mode of election of the dispute at hand, the mode of voting of the election at hand is by way of electoral college. By way of electoral college under section 14, subsection 1 of the PEA. And will not occasion any prejudice to the parties. Your Worship, I now invite my learned friend to submit and conclude.
Your Worship, to supplement for the report to West Chicano.
Wesije.
West Chicano.
Wesije enough.
Your Worship, I submit that there is cogent evidence to show that the tallying process at the polling station in Kiso was not free and fair.
The what?
There is cogent evidence to show that the counting process at the polling station was not free and fair. And this evidence can be ascertained from the second page of the declaration form, which is attached as Annex D with affidavit support.
Ascertained from? The second page.
The second page of the declaration form, which is attached as Annex B to the affidavit support. Your Worship,
Annex.
that is Annex B.
Yeah.
Affidavit support. Presiding officer indicated on that second page that the agents for umpiring Vienna were present but left before signing on that declaration form.
The agents of the applicant.
The agents of the applicant who were present at that polling station left before signing on the declaration. Your Worship, one of the agents of the applicant was present at the polling station, that is Taiba Collins. This application
It's called Talemwa.
is called Taiba Collins.
Or Riahebwa.
Collins swear an affidavit clearly explaining the reason as to why he left without signing on the declaration form. And the gist of his evidence is that the counting and even the tallying of these votes was not carried out in a fair manner as required under the law.
On ground of that.
And the gist of his evidence is that the counting and tallying process
The
was
counting.
the counting
And
of
tallying.
the votes was not carried out in a fair manner as required under the law. Your Worship, when you read the decision in Winnie and Mangini, which is already on court record,
Pardon?
when you read the decision of Winnie Yanima versus Mangini, which is already on court record, and we highlighted the relevant page, the judge made it clear that one of the rationale of a vote record before the chief magistrate is to ensure that there is a fair exercise of establishing the proper votes. Your Honor, we highlighted the relevant page.
One of the reasons for conducting a recount.
One of the reasons for a vote record before a chief magistrate is to provide an independent avenue of verifying the vote counting process.
For verifying.
Of verifying the vote counting process. Your Worship, in the 1 minute, I have been notified by the court.
Pardon?
1 minute.
We had agreed. You forgot the rules. You
Your
said the
Worship,
rules.
that's my prayer.
Okay. Unless if parties here agree to extend time, council can extend time. Do you want to extend time or we cut him short? Some space?
Interest of justice.
Okay. 5 minutes. Conclude.
Worship, that's the worship.
I hope you will do the same.
We have no problem really.
Okay, go ahead.
Your Worship, in a case like this one, where there is a polling agent clearly demonstrating, and
Where there is?
where there is clear evidence of a duly appointed polling agent, clearly giving evidence, clearly giving evidence of unfairness in the vote counting exercise. A vote recount would be necessary, and that is a just cause in order for that to be recount.
Okay.
Your Worship, finally, the margin between the applicant and the respondent is only 18 votes. That is the alleged margin. It's only 18 votes.
The implication of that, I don't understand.
Your Worship, when you are looking at circumstances under which to carry out the verification, even the vote margin becomes relevant in my view.
Well, I mean to recount before a chief magistrate, is it material to know?
It is not material, but also it can be one of the considerations. Because the challenge under the statute, it does not outline any consideration. Section 74 is silent on what we need to prove. But
Okay.
we are showing some of the circumstances for a just cause in order for a vote to come. And that is one of them according to us, because it is also a numerical aspect of this process. So you are Honor, on those grounds to pray for God to allow this.
Okay. So submissions from the first respondents.
May I please, Your Honor?
His Counsel Honorable Basari.
Your Honor, we have instructions to oppose this application. Affidavits in reply, Your Honor, were filed, and we ask court to adopt the amendments in those affidavits.
Have that place in reply? Were filed?
Were filed, were duly filed.
Okay.
And we invite court to adopt the amendments in those affidavits in reply that are on court record.
Yeah, you're on record.
Your Honor, having said that, we wish to specifically observe that one, in the history of this country, this was the most supervised election, because the entire machinery of the Electoral Commission was present. And supervised by the chairperson, as indicated in paragraph 9 of the first response affidavit in reply. Your
Which
Honor,
paragraph?
paragraph 9. Paragraph 9 of the first respondent's affidavit in reply. Your Honor, this was an election that had live coverage and wide publicity.
Wide coverage?
Wide coverage and live publicity. Again, as indicated by the affidavit of Mwesugwa Alan John, paragraph 5. Mwesugwa Alan John,
Paragraph 5.
paragraph 5. Your Honor, it is therefore inconceivable that the alleged errors could have occurred in the presence of the entire EC machinery and they would have gone unnoticed. It is inconceivable, Your Honor. Your Honor, we are further fortified in that argument by the affidavit of one of the candidates in that election, Muhumuza Julian, who, Your Honor, for the record is in court. One of the candidates in that election. Your Honor, Muhumuza Julian. Julian.
Oh, Julia.
Yes. Who was one of the candidates in that election. Specifically, in paragraph 3 of her affidavit in reply, she confirms that the entire counting and tallying process was carried out in a free, transparent, and fair manner. So one of the candidates is not an agent, but is a candidate who had a bigger stake than even agents. Your Honor, she further asserts in paragraph 5 that the process of counting and tallying of votes went on uninterrupted by the second response officers under the watchful eyes of our agents and in our presence until the last vote was counted and tallied.
She further averred how?
That the counting and the tallying of votes went on uninterrupted by the second response officers under the watchful eyes of our agents.
Uninterrupted by?
By the second response officers under the watchful eyes of our agents and in our presence until the last vote was counted and tallied. But Your Honor, what is even more important in this affidavit is paragraph 6, where this candidate in this election states that the outcome of the election,
the same candidate?
Yes, Muhumuza Julia, that the outcome of the election was a true reflection of the will and mandate of the youth. And she says that as a participating contestant, I wish to state that the first respondent won genuinely in a free and fair election. Your Honor, This
Was
is
a true reflection of the youth,
yes.
of the youth mandate.
Yeah, it was a true reflection of the will and mandate
Of the will.
and the mandate of the youth. And that as a participating contestant, she states that the first respondent won genuinely in a free and fair election. Your Honor, I'm emphasizing that this was a candidate in this election.
She stated that
That
the first respondent
won genuinely in a free and fair election. Your Honor, that evidence is consistent with the affidavit of Mwesgwa Alan and the first respondent herself, Kanyesije Masi. And all this, Your Honor,
Mwesgwa Alan and
Kanyesije Masi, and Your Honor, all these were present throughout the entire tallying and declaration of results process. They were present.
okay.
Your Honor, this is a clear indication that there was no problem with the tallying and the counting of results as indicated by the applicants. Your Honor,
Of results as indicated.
by the applicant. Your Honor, counsel for the applicants asserts that over 230 votes, of the applicant were attributed to the first respondent. That the over 230 belonged to her as the applicant, but instead they were attributed to the first respondent. Your Honor, there is no evidence on record. There is no evidence on record to indicate that this particular witness was able to differentiate and know at that particular point and be able to count over 230
Was able
to differentiate, to know at that particular point that these over 230 don't belong to the first respondent, but they actually belong to the applicant. What magic! And even if it was to apply artificial intelligence in that moment, this is completely inconceivable. Your Honor, the duty to count is a responsibility of the second respondent. It is not the responsibility of an agent. The duty to declare a valid or invalid vote is also a responsibility of the second respondent, not an agent as alleged. Your Honor, as I summarize, this figure of 230, which is becoming a magic figure, the figure 230, which is a magic figure, by the applicant is allegedly stated by a witness who would describe as an arithmetic guru.
The applicant is what?
Who would be described as an arithmetic guru?
By the applicant who?
The witness.
By the witness.
The names of Tuyahebwa Collins. Under paragraph 4. Under paragraph 4.
Was unable
to ascertain the whether participants in this for there to create an arithmetic challenge necessitating a vote recount. Your Honor, I will conclude that going by this imagination of 230, the authorities we cited and that have been referred to here come into play, Your Honor.
okay.
That one, an application for a recount is concerned with the numerical correctness of results. Numerical correctness of results.